The problem at hand is that weak IP regimes in certain countries harms the American business interest. The most comprehensive international agreement on IP is the trade-related aspects of intellectual property rights, otherwise known as TRIPS, as administered by the World Trade Organization. TRIPS sets down minimum standards for many forms of intellectual property regulation as applied to nationals of WTO members. Within this provision, TRIPS provides flexibility for each nation to operate within its requirements that best advances their economic interests. Consequently, there is no international consensus on the optimal level of enforcing TRIPS. Some countries use this flexibility to set a weak IP system that comprises the commercial interest of global patent holders and creates barriers to the flow of innovations. For example, weakly enforced IP regimes encourage the practice of counterfeits, which negatively impacts the revenue of global businesses and deters international exports. According to the ICC, they expect the value of counterfeit goods globally to exceed $1.7 trillion by 2015. That's over 2% of the world's total current economic output.
Patent rights are territorial and their enforcement is subject to each country's discretion. Although TRIPS is an advancement towards a more unified system, social enterprises and non-profit organizations remain disadvantaged in a global IP regime that calls for more costly legal expertise and services. Before a firm wants to file an international patent, they must understand on a risk, such as determining if it's beneficial to file a patent in a certain country and determining what type of patent to file. Also, understanding what IP rights they are allowed to exercise and how to go about exercising these rights. Having legal expertise is crucial for all these considerations. However, legal advice is considerably expensive. Even if these firms want to file patents that can improve the global community, they may be unable to because of limited resources. In order to increase innovation and social entrepreneurship, free or reduced legal advice is crucial. My Startup is an online system database that connects lawyers that offer pro bono services regarding international patent with nonprofits and social enterprises. Certified lawyers can sign up and include their area of expertise and availability to advise or adopt full-fledged cases. Small businesses, small social enterprises and nonprofits can then search and match with these lawyers. The startup will begin as an online-only matching database to keep the cost overhead low. Outreach will include free international IP workshops in collaboration with organizations such as the American Bar Association and university law schools that offer pro bono services. Regarding funding, there are various organizations that offer funding for operating pro bono services, such as the Pro Bono Innovation Fund. Upfront costs will be running the organization and low fees in hosting the online system. The organization will be volunteer-based. Duties such as designing and producing an online service can be outsourced to a programmer with internet access, while more legal positions will be occupied by certified lawyers. Through this management system, estimated cost for operating the startup is considerably less than hiring employees full-time. Currently, there are many places that offer pro bono services. Although there are online databases that curate different places across the nation that offer IP services, businesses and individuals have to individually contact each firm, and even after the initial contact, service is not guaranteed. Therefore, nonprofits and social entrepreneurs that are already operating under limited time and funding will lose valuable time and effort in this process. The global IP environment is moving towards stronger regulation in the IP. It's moving towards stronger regulations in IP. Therefore, expert advice is even more crucial in furthering the social health of the international community.
The current IP system TRIPS is the main issue we intend to deal with. TRIPS allows for countries to interpret it with flexibility. When it comes to patent protection, underdeveloped countries take advantage of this. As a result, a weak IP system is in place within that specific country. The weak IP enforcement allows these countries to exploit the flexibility in a couple ways that is detrimental to certain sport industries. First First, rip-offs and counterfeit products are mass-produced and directly affect the global markets that corporations such as Nike, Adidas, and Puma try to expand into. In addition, SMEs, or small to medium-sized enterprises, are the most susceptible to this issue because it stifles innovation and slows economic growth. Intellectual property theft has an adverse impact on innovation, commercialization of new products, and overall economic success. SMEs are particularly vulnerable because they are at a distinct disadvantage in securing IP rights in foreign markets and confronting its theft. In 2012, the major professional sports leagues in the United States lost over $13 billion in revenue due to sales of counterfeit jerseys and apparel. For the last 4 years, counterfeit footwear has topped the seizure list of the Customs Service, with the global athletic apparel industry in total set to reach $125 billion by 2017, which includes athletic shoes. The market potential is vast. Fast-paced trends and technologies drive this trend, not to mention the brand market appeal. In addition, the rise of contract manufacturing, globalization, and the internet makes it easy for counterfeiters to target the most popular brands, infiltrate the supply chain, and profit from the sale of knockoffs. The counterfeit threats are enormous, such as loss of market share, lower profits for diverted goods, and loss of brand integrity. Our nonprofit consulting agency helps small to large corporate companies expand and protect their patents globally, specifically in the sports corporations. Our strategy is to combat counterfeits, where we will implement a brand protection strategy that will help secure the supply chain. We will take on this challenge through a 3-step process. First, we will develop a universal technology for products that proves its authenticity. Secondly, we will work to create some sort of enforcement agency involving companies like mine that utilizes this authenticity technology, therefore creating awareness. Lastly, we will enforce strong IP rights both online and offline through advancements in TRIPS to promote a stronger IP system. As a result, these companies will benefit not only commercially but also strengthen their brand globally as a whole. This 3-step combination will work to establish a strong understanding for brand authenticity and prove to be useful when dealing with counterfeiters in litigation. In addition to safeguarding their IP, we will ensure that we will seek out counterfeit industries that are making an impact on the brand image and also act to prevent those from expanding into a threat. To do this, we will work with the Stop Fix program to ensure that IP is the driver of innovation and propose our plan to combat counterfeit products. We will generate revenue by consulting fees from the corporations themselves, and we plan to measure the impact we are making through the rate of approval of patents filed through us and the growth rate of the specific market each individual corporation wants to expand into.
I propose a non-profit intellectual property consulting and lobby group focused on the Chinese market. Our mission is twofold. We will help the American companies to navigate through the existing patent system. We'll also help improve the Chinese IP protection standard. We believe that the Chinese market has a huge potential for U.S. firms to tap. Firstly, because the Chinese people is in great need of safe and reliable foreign goods. That is because numerous public health crises have destroyed Chinese confidence in the quality of local products. This lack of confidence drives customers to foreign products that they believe have a higher quality. The cross-border e-commerce is booming since 2011. A study has estimated the market is about $60 billion and with the potential to reach $100 billion in 5 years. American companies could capture part of the huge market by expanding to China and selling goods directly to its people. Secondly, Chinese firms also in need of foreign technologies. Most Chinese phone makers are still relying on Qualcomm for chipset and Sony for cameras, which are the most expensive parts of a smartphone. This leaves a very small profit margin for the Chinese phone makers. Another example, Chinese automobile firms have yet to develop their own engines and original exterior designs. The American business will benefit by Chinese firms' continuous demand on machines and technologies. Thirdly, although China has improved its IP protection measures steadily, the country's patent protection system is still far from satisfying. The market has a rampant counterfeiting problem. The judiciary system is prone to corruption and biased. And the patent enforcement agency is dangerously understaffed. Moreover, the Chinese government may unfairly target the foreign firms for economic sanctions with a political intent. And here is we come into play. We provide an IP solution for expansion into the Chinese market. Our comprehensive strategy starts with a preliminary evaluation in the intellectual property environment tailored to each client. We'll notify clients of any existing intellectual property infringement. We will then provide the intellectual property portfolio to register with the Chinese authority to best protect the client's interests. If the client's intellectual property were infringed upon, we would also work with local authorities to ensure reasonable compensation. However, we do realize maleficent parties could exploit existing Chinese intellectual property system to damage our clients' interest. Therefore, it is also our mission to push for regulations and law changes that will better serve the interests of global innovators. We will pressure Chinese government to change from within and out. Our firms will work closely with all businesses with the interest of tighter IP standard in China. More, we want the U.S. government to pressure Chinese authority in the trade talks. Our revenue will be generated through the consulting fees, and our lobby grant will be collected from member companies of the U.S. Business Council. We will measure our compacts through the patent filed by U.S. companies and the wins by U.S. companies in IP-related cases in Chinese court. We will also help to publish a white paper by U.S. Trade Representative Office on Chinese patent regime.
Global solution. We believe the global community will benefit from stronger and more consistent IP standards. This can be achieved in a two-step process. Number one, by adding stronger patent enforceability provision in future FTAs. And number two, engaging more countries through FTAs to harmonize towards a stronger IP environment. Strong IP patent laws will benefit a country's economy. For example, Canada increased its exports by imposing stronger patent protection. Our belief of this best course of action has been confirmed through the recent TRIPS Plus movement, spearheaded by US and EU. In TRIPS Plus, countries add provisions to federal trade agreements to increase enforceability. For example, in the early 2000s, bilateral U.S. trade agreement with Jordan, the U.S. helped Jordan construct a stronger IP protection system that would deter counterfeit and increase innovation flow. However, a country's weak patent system acts as an export barrier because of the threat of imitation. Therefore, provisions that increase IP enforcements for patents in threatening countries may eliminate the barrier. In general, some provisions that we believe are highly beneficial are A. Patent extensions to compensate for delays in the patent filing procedure, and B. Judicial reforms that would ensure reasonable punishment for patent intrusion. We believe provisions such as these directly improve the main constructs of the patent system. As more countries enforce stronger IP, other countries would feel compelled to opt in. Consequently, nations that retain weaker IP environments may lose future investments. By proposing provisions in bilateral agreements, the hope is that it would eventually create a network effect as more countries follow suit. As a result, a more universal interpretation of TRIPS would be formed without directly modifying TRIPS. This saves time and energy. These provisions engage countries with different TRIPS interpretations on a one-on-one basis, which can be applied accordingly to each country's needs, whereas modifying the original trade agreement would take more strenuous time and effort. Moving forward, we want to strengthen TRIPS Plus by including these provisions in future FTAs.